So the court doesn't just make a decision by reason of the submissions that are made to them in the court with regards to custody. Yes, it's absolutely considered what the council has set out to them, but they have to look at it at all times under the legislation protecting the best interests of a child. So when somebody presents who maybe has an addiction issue, maybe has a gambling issue, where joint custody may not be in the best interests of the child, the court will not grant it. They'll say it's premature, come back another time, or they'll adjourn it for the person to be given the opportunity to change their lifestyle so that the court will consider it then. In the district court, with regards to custody applications, generally the applicant and the respondent wouldn't have been married. So there would be an application generally in most cases by dad, to have him appointed as a joint custodian with mum. That's a separate application. It's done in the district court and both parties have to attend and either agree before you go in that joint custody can be granted, or else if there's an objection, set out why the court shouldn't consider an application for joint custody in the best interests of the child, not in the best interests of the adults. Where a couple are married and the child is born while they're still married, there's automatic joint custody in Ireland. So with regards to divorce and judicial separation, sometimes the court is asked to decide if the parties are to retain joint custody or if one mum or dad are to have sole custody. What we've seen is that in the best interests of the children, which the court has to look at, is that joint shared custody is maintained even after the divorce is granted.